Yeah. Yeah.
Okay, just bear with me, Mr. Fagan. I need to check if Advocate Kazi is on board. Advocate Kazi?
I don't see your face.
Please, I'm here, my lord.
We can hear you, but we can't see you. And that's okay with you. Can you hear the proceedings, Advocate Kazi?
She must have pressed the button there. If she, I think she can you hear?
I can't hear. Thank you.
Okay, thank you.
My lady and my lord.
And then before we start, Advocate Fagan, there is an affidavit that we received this morning from the second respondent, Mr. Mugaito.
Yeah.
Yes.
Well, it was it is an affidavit responding to the late edited by Professor Baldwin.
Yes.
And it only addresses those two issues. I don't need to take the court through it.
No.
I don't need to make any oral submission.
What I wanted to determine is whether there is from any of the
Yes, we have not had any indication.
indications. Mr. Fagan, any issue with Mr. Arence's affidavit? No objection. Thank you very much. And the rest of the team? Thank you, Mr. Buket. All right. We may then, you know that today the proceedings are such that we will proceed until we finish the matter. Yes.
Learned friend, Mr. Katobi, said that we misapprehended the law pertaining to rationality review, and we shall show that we did not. We also said that we have sought to rely on a breach of fiduciary duties, an infringement of constitutional rights, and a failure to consult with stakeholders, but that Professor Mendelsohn failed to plead any of this. We shall show that fiduciary duties, constitutional rights, and a failure to consult were pleaded. By contrast, we shall show that the defences that were raised by our learned friend are for the most part unpleaded and therefore cannot be relied upon by UCT. Turning first to rationality review, in the founding affidavit, we relied both on legality review and on administrative review. The decision of a public school's governing body to change the name of the school is considered by our courts to be subject to Paja review. So that's a decision by an organ of state exercising a public power in terms of legislation which adversely affects rights and has a direct external legal effect, using the definition of administrative action in Paja. That being so, it's hard to see why at least the adoption of the second resolution would not also be subject to Paja review. It has, however, been unnecessary for us to press this point because legality review suffices for the purposes of Professor Mendelsohn's case. Our learned friend, however, submitted that we overlooked the three-part test for rationality based on a failure to take into account relevant materials, and he referred in this regard to the judgments in Democratic Alliance, what's known as the Similani judgment, and Scalabrini. In fact, as I shall show the court in a moment, our heads of argument follow very closely the application of the three-stage inquiry in the Democratic Alliance case as applied by the Constitutional Court in ETV. That's in fact one of the judgments which we handed up. And if I might ask the court just to have regard to that, we handed up an extract from it. In paragraph 74 of that judgment, this is the ETV judgment. In paragraph 74 of that judgment, one will see that the Constitutional Court quoted from the Democratic Alliance judgment the passage where the three-stage inquiry is set out. First, whether the factors ignored are relevant. Second, what must be considered is whether the material is rationally related to the purpose for which the power was conferred. And the third is whether ignoring relevant facts of a kind that colors the entire process with irrationality and thus renders the final decision irrational. As to the first inquiry, the relevance of the factors that were ignored, the court dealt with this in paragraph 75 and 76 of that judgment. It had to do with the relevance of knowing how many households qualified for set-top boxes and wished to register for this before analog TV was switched off. We dealt with the relevance requirement in the present matter in paragraph 30 of our main heads, our heads on the merits. We said there a real risk of losing substantial donations to the direct benefit of students and staff is relevant to whether a decision like passing the resolutions is in the best interests of the university. As to the second inquiry, namely whether the failure to have considered these factors is rationally related to the purpose for which the power was conferred, the court in ETV dealt with this in paragraph 77. One of the purposes there was to mitigate the harm caused by an analog switch off. And we dealt with the purpose requirement in this case in paragraphs 29 and 32 of our heads of argument. In paragraph 29, read with footnote 58, we set out the purpose of the power, namely to govern in the best interests of the university. And in paragraph 32, we described why the failure to consider the impact of the resolutions was not rationally linked to taking a decision in the best interests of the university. As to the third inquiry, whether ignoring relevant factors of a kind that colors the entire process with irrationality, rendering the final decision irrational, this was dealt with in the ETV judgment in paragraph 78. The determination of the switch-off date having been made without any reliable sense of its impact on millions of indigent persons, the process was colored with irrationality and the decision was accordingly irrational. We dealt with this third requirement in paragraph 33 of our heads of argument, using, in fact, the identical language. We refer to a process that failed even to consider these adverse impacts, i.e. for UCT staff and students, is inevitably colored with irrationality. So we very precisely did follow the three inquiry process, as it were. Just on that, why is there a third step? The court understood that sometimes a failure to consider relevant material may not be linked to the ends, but nonetheless the process as a whole otherwise mitigates that irrationality for other reasons. For example, take an example that was raised from the bench. A medical board may have overlooked a new study showing a medicine causing a mild allergy, but because it considered another earlier paper showing no serious side effects, does not mention allergy, its failure to consider the new study does not color the entire process with irrationality. In the present case, there was no such mitigation. So that then, as to what we set out in our heads of argument in that regard, then dealing with the issue of Professor Mendelsohn's pleaded case, contrary to what was said by our learned friend, a breach of fiduciary duties is squarely raised on the pleadings. A word search that we conducted indicates the following: breach of fiduciary duties on the part of the council and its members is alleged 3 times in the founding affidavit and 7 times in the supplementary founding affidavit. I can ask the court to have regard to one of these in volume 3A. My apologies.
3 times in the founding and how many times in replying?
7 times supplementary.
With regard to one of these in file 3A at page 359, paragraph 11 of the supplementary founding affidavit. Paragraph 11. This case concerns council's statutory duty, in brackets must, to govern UCT, concerns the question of whether council acted in the best interests of the university. It is concerned with whether council's process leading to the resolutions accords with the principles of legality, good governance, and fiduciary duties owed to UCT. Moreover, UCT recognizes our reliance on breach of fiduciary duties and accepts that council is under such a duty. And an example of this may be found in the answering affidavit, paragraph 375, in file 4A at 1125. Where, having referred to Professor Mendelsohn, saying the council fell short of the governance responsibilities, it said in paragraph 375, the governance responsibilities described above are on all fours with the council's overarching fiduciary duty to govern UCT in its best interests. The question of infringement of constitutional rights was also squarely raised. In the founding affidavit above paragraph 45, in volume 1 at page 33, there's a heading, the nature of the right to freedom of expression. Paragraphs 45 to 49 deal with this right, including the sub-right of academic freedom. And then paragraph 68 to 73 from page 51 on allege an infringement of the right. Regarding the failure to consult stakeholders, this too was raised in the founding papers. If I might ask the court to have regard to the supplementary founding affidavit, volume 3A, page 432. The court will see that in paragraph 152, reference is made to UCT's risk management policy. Paragraph 154 refers to the King IV Code. Paragraph 154.3 specifically says the code obliges council to adopt a stakeholder inclusive approach. And we say over the page, council did not do so. And at 156, we say these duties are critical and had to assess various things. And 156.3, we refer to the views of the AFC, Senate, affected students and staff, and the broader UCT community. The founding papers also expressly referred to the failure to have followed a process similar to that which was followed by council in 2019, which was a very broad consultation process with stakeholders. And this we say again in paragraph 142 of the supplementary founding affidavit at page 428. We refer to Annexure A, which provides a list of people interviewed or consulted by UCT. In 2019, that's the Senate's survey, I believe. And that can be read with, in file 3B, page 830. Where one can see what was done then. Then in paragraph 143 in the supplementary founding affidavit at page 428, we refer to the survey results. And the numbers are really impressive. 2,353 submissions were received. Around 65% of respondents opposed the 2019 resolution. This is the result of consulting with stakeholders then. And again, without the court having to go there, but that can be read with pages 848 and 880 at volume 3B. So what Professor Mendelsohn did was to contrast the extensive 2019 process with the failure of the council in 2024 to have consulted or considered the views of others. And then in paragraph 130.1 of the supplementary founding affidavit at page 423, there's a very specific non-consultation point raised, and that's with the Neuroscience Institute. That's 130.1. So we have not deviated from the pleaded case in summary. If I may then turn to UCT's new defenses. because the same cannot be said of it. It has deviated from its pleaded case by introducing a number of defenses that were not anticipated by the numerous and lengthy affidavits that were filed on its behalf. These are fact-dependent defenses. The introduction at the argument stage of these proceedings is highly prejudicial to Professor Mendelsohn, and they cannot be relied upon. The new defenses are these: a moral imperative unconstrained by any need to consider the impact on UCT. So moral impact unconstrained by any need to consider the impact on UCT. Mootness, curing, and ripeness. On the first point, in its papers and heads of argument, UCT accepted that the moral imperative of adopting the resolutions needed to be justified in order to be rational by reference to their purpose. And it's undisputed that the purpose is the best interest of the university. So UCT asserted that the justification lay in two benefits to the university. First, the protection of freedom of expression, and second, the reputational benefit of preserving the standing of UCT among the leading research universities in the world. In argument, however, our learned friend, certainly initially, diverged from UCT's position as per its papers and heads by arguing that Council's goal in adopting the resolutions was to express indignation at Israel's conduct in the war in Gaza and solidarity with Palestinians. That goal renders even Council's limited cost-benefit analysis superfluous. The moral imperative of adopting the resolutions was such that even the alleged benefits to UCT were irrelevant. Simply put, no account at all needed to be taken of the impacts on UCT, whether positive or negative. As the members of Council hold fiduciary positions and are statutorily constrained, sorry.
Just with regard to that, the moral imperative. And I think one of the points made by Mr. Gatoibi was about the quantification of the costs.
Yes.
And the cost benefit analysis. Now, and I think that's what also that's a lot that we grapple with in society in South Africa also. Sometimes you have to take a stance based on moral imperatives, constitutional imperatives. The question here is that, are you saying that the cost to the university far outweighs the moral imperatives in taking that, or making that, or taking these decisions? For Council to have come to these conclusions and to have made these two resolutions.
We are taking a process. We are saying,
consider what the impact was. That was its duty, not, in other words, they didn't do any weighing at all. So we're not saying.
The point with the rationality review. And I think this is what we're dealing with here. And the question about how far do you consult? Let's for instance take the DF Malan case, the Rotenbach case. If the process of consultation that they had not adopted in the manner they did adopt, the moral imperative of getting rid of the name of the school of an architect of apartheid would have been undermined, in my view. Speaking for myself, that's why university, they said, and that was a positive review. That's why the school governing body said, let's get an expert in this. If we should take a vote in South Africa today about the death penalty, by far the majority of South Africans, I would imagine, would say, bring back the death penalty.
Sorry to hear.
Yes, you know, I'm just speaking for myself. Oh, let's take a simpler. Let's not pay taxes, something like that. The question about the moral imperative that we have to. So sometimes the moral imperative, the weight of the moral imperative. And sometimes we have to make a decision with regard to what we are constrained in terms of the Constitution. We are constrained to make decisions on moral issues. In this case, based on the Constitution, dignity, right to life, all of that. Which there was heavy debate. There was heavy debate in council, it seems, on the transcript about those issues. And I think it was raised, well, also I think it was raised, I think page 482 of that 481 and 482 of that, speaker 11, speaker 8, all of that, speaking about that. And they said the financial implications is a different consideration than the moral imperatives. So when it comes to a rationality review, and I may understand the case law differently, but when it comes to certain executive decisions, and a relative review is about the ends and the means test. The means to get to that end, rather. So are you saying that the means they got to it, if one should accept that there was some, which was denied by the respondents, that there was a mislead, intentionally council were misled by those 5 members of the executive about the withdrawal of it.
Why the intentional approach for this?
Whatever. But it was not, there was a duty upon them, at least the fiduciary duty upon them to do so. And if one looks at the moral imperative in the end. So are we saying here that the weight of that is such, and us, we as a court, and with the 2019 also that risk assessment in mind, are you saying that we as a court must say that the financial implications to UCT, even if it was not disclosed to the full council, far outweighs the moral imperatives of those resolutions that were taken? Or are you not saying that?
We are saying there was a failure on the part of the council to weigh these things up. We're not saying how they should weigh. We're saying there was a failure to weigh. Because bear in mind, my lord, the Constitution also requires organs of state to reach their decisions in certain ways. In other words, they are constrained. They're not private persons who can jump to any conclusion they like because they're organs of state. So that is the point.
Mr. Thinking, just to check my understanding, if I understood Mr. correctly, he was almost saying that the scrutiny in a review of this nature is far less than it would be in an ordinary Pager review, for example. And he was saying, if in the meeting of the 22nd of June 2024, the issue about the impact of the financial impact was raised and it was discussed. And it is not up to the reviewing court now to dig deeper and say that these are the questions you should have asked. You should have asked for more.
I'll respond to that. That's precisely what the reviewing court should find. In other words, how do you weigh if, quote Lordship Mr. Justice, sure, you've put nothing in the scale, on the scale perhaps. Yes, but I'll come back to this point.
But he refers to the Clarison's case, and which was later followed in Pepco, and they referred to Baxter. They said the court will merely require the decision maker to take the relevant considerations into account. In this case, there was a debate. It was speaker number 11, if I'm not mistaken, Mr. Takeover, who said we're talking about financial considerations, and he said something about, or he or she, I can't remember, I don't know who it was. There's no name mentioned, so I don't know who it was. They said, but that is not that we have to take into consideration here, or they considered that. Now, from my understanding, based on what Baxter says, as quoted in the case of Mr. of Clarison, it says the court will merely require the decision maker to take the relevant considerations into account. It will not prescribe the weight that must be accorded to each consideration, or to do so could constitute a usurpation of the decision maker's discretion. The law remains as we see that when a functionary is entrusted with a discretion, the weight to be attached to that particular factor, or how far a particular factor affects the eventual determination of the issue, is a matter for the functionary to decide. And as he acts in good faith and reasonably and rationally, a court of law cannot interfere.
Difference between the question of how much weight to attach to something and to decide on an a priori basis, we are not attaching any weight to this. Yes, they decided not to consider the financial implications. That was the decision. And with respect, how does one discharge one's fiduciary obligations to an institution by taking that approach?
That's not how I am. The reading of the transcript, but I will have to go back to it. Page 48, I think it's 481, 482, 483 of that bundle. But they referred to it, and they said every time when there's a decision about this and something about anti-Israel, the issue of funding comes up. No. Yes. No. That was the argument that was raised there. Financial implications. So, the question is: it for us to determine what weight they should have attached to?
Determine whether weight should be attached. As your lordship pleases. So Because the members of council hold fiduciary positions and are statutorily constrained to act in UCT's best interests, bearing in mind that is the purpose. They must act in the university's best interests. Always that's the touchstone here. The extreme position, therefore, for which our learned friend advocates, is simply not legally sustainable, because being a fiduciary requires that every decision be preceded by a cost-benefit analysis. And why? Because fiduciaries do not act in their own interest, but they act in the interest of others. If the goal were purely to express indignation, moreover, this could have been done by way of a further public statement along the lines of the December 2023 statement. There's no need, if that's all you're trying to do, to harm the university in the process. So that on this, as it were, call it the more extreme version of UCT's case as per its heads. Turning then to the points of mootness, curing, and ripeness. These are all in limine defenses. UCT raised one in limine defense, which was misjoinder. It hasn't persisted with that defense. It's raised none of these as an in limine defense or as a defense at all. And it is in our submission telling that UCT saw the need to try and introduce new defenses at such a late stage, and it did it because the facts in this matter weigh so heavily against it. If I may just take the court through those defenses in context. Although impermissibly raised, we shall deal with these new defenses. We shall show where UCT has introduced them in response to various grounds of review. Before embarking on that exercise, I wish to make this point to show the extent to which UCT is searching desperately for a viable defense. By raising both mootness or curing and ripeness as defenses, UCT is saying the application for judicial review is both too late and too early. It is too late because council took subsequent decisions that overtook the earlier decisions, and is too early because we are told UCT has yet to make a final decision. That cannot be with respect. There's a judgment in the SCA, Permanent Secretary, Department of Welfare in the Eastern Cape. We shall shortly hand up a bundle of authorities, but not quite this moment. And in paragraph 14 of that judgment, Cameron J.A. said it's contradictory for a party to raise both mootness and ripeness as a defense. He described the Eastern Cape government in that case as having recourse to every stratagem and device and obstruction, every legal argument and non-argument that it thought lay to hand. By raising both mootness and ripeness, UCT has adopted a similar approach. More recently, in the case of Buffalo City versus Asler Construction, 2019 4 SA 331, Constitutional Court, para 99, Constitutional Court made the following finding regarding the conduct of an organ of state in litigation, and we submit this applies aptly to UCT's conduct in defense of this application. The court said this: at no point did the municipality take the court into its confidence and explain its conduct. It simply presented the court with whatever view it felt suited to at the time, vacillating between positions when convenient to it. This is outrageous behavior from a state litigant, which must be robust in upholding its constitutional duties and is to be held publicly accountable. The municipality's conduct in this matter verges on bad faith. So raising the contradictory grounds of mootness and ripeness means that neither can be relied upon by UCT. It is not for the court to select between two defenses that cancel one another out. The court is in no position to do so. These are fact-dependent defenses. As a matter of policy, too, as the judgment of Cameron J.A. makes clear, it cannot be permitted for an organ of state to raise scattergun inconsistent defenses to an application for judicial review in the hope of that one of them will come home. May we hand up a document which is just to make it easier for the court. It has the references in, so it's a short document, so the court doesn't have to make notes of every case we refer to and every reference, and also some additional authorities.
We know from the papers that subsequent to the decision of the 22nd of June, Council, those two decisions of the 15th of March and the 29th, we know they're in the papers already that these that are challenged right now, they were considered, they were reconsidered. And when they were reconsidered, that's how the papers read, correct me if I'm wrong. When they were reconsidered, the financial considerations were a big part of the reconsideration. As a court, are we not entitled to ask ourselves if these resolutions that are before us have already been reconsidered on the very basis that is being assailed by the applicant? What do we do with that? Because we know that we have to interrogate what effect is it going to have then to review that which has already been technically set aside by a subsequent judgment. We're not entitled to do that?
Leadership, there was no reconsideration. There was no proper investigation of the financial consequences. That was an entirely different decision.
But they said there was a decision on the ultimate decision. I think it's placed. It was paragraph 285 of the answer. Somewhere it was according to Mr. Katobi, it was pleaded. We have a decision of the 22nd of June 2024, 15th of March 2025. So are you saying that the decision in applying, let's say, Odekral of the 22nd of June, notwithstanding the decision of the 15th of March of this year, still stands? In fact,
Yes.
although so are you saying until set aside by this court? And the argument by UCT in terms of the statute which they presented to us here, I think it's at 20G. A motion to rescind the resolution of the council within 12 months after it was passed requires blah blah blah. So they have that power. So are you saying that did not happen? And are you saying that the decision then still stands and of the 22nd of June and forced to be set aside?
And was that it wasn't rescinded. So it's common cause that it wasn't rescinded by the university. So therefore it stands, yes. That's the consequence of not rescinding it.
And where is that? On what basis do you around that? Where do you say, where is that in the papers? That
There is a decision.
What is the resolution taken? That, or no resolution taken? The decision of the 22nd of June 2024 is rescinded and it will be reconsidered during this session of council. Is it nothing of that kind?
No one's case. That's no one's case. UCT has not said that. No one has said that the resolution was rescinded. All that UCT said that there was a motion to rescind, which was defeated. So the resolution stands. No one has rescinded.
And that was taken
Not to rescind.
on the 15th.
Yes. As the court pleases. We've handed up this reference document. We have 6 grounds of review. As Mr. Perumal-Sami warned counsel with reference to authority, an applicant for judicial review needs to succeed on one ground only. Professor Mendelsohn's first ground of review is that counsel acted irrationally by failing to consider relevant considerations. And UCT's defense to this ground is twofold. One is that counsel acted for a moral imperative, and 2 is that the application is moot. That was what was submitted to the court in argument. The second ground of review is that counsel failed to consult with stakeholders contrary to its statutory duty, and UCT's defense is a denial of a duty to consult. The third ground of review is that the chair and exco deliberately failed to disclose known relevant material contrary to their fiduciary duties. UCT's defense is that relevant donors never threatened to terminate their agreements if counsel passed the resolutions. And the fourth and fifth grounds of review are that the terms of the first and second resolutions fail to link rationally to a legitimate purpose and that they are unreasonable. And UCT's defense to this is ripeness. And our submission is that UCT's defenses do not withstand any scrutiny. We have 9 reasons for this, and that these are make up the structure of what follows in that document that was handed up. These reasons, moreover, support Professor Mendelsohn's 6th ground of review, which is bias, and they also support the costs award sought on his behalf. So the first reason then is the test for rationality. All exercises of public power must be rational. We referred in our heads of argument to the Nurser judgment that has now been handed up to the court. And in paragraph 48 of that judgment, the court says rationality depends on whether the means, including the process of making a decision, are linked to the purpose or ends. The means for achieving the purpose includes everything that is done to achieve the purpose. That's what the court said in the Democratic Alliance judgment of paragraph 36. There, the president's decision to appoint Mr. Similani as National Director of Public Prosecutions was not set aside because Mr. Similani was a bad person, but because the president had failed to consider evidence arising from the Ginwala Commission. So a failure to take account of what was necessary to come to a rational decision. And Similani, just to note, was decided on the basis of, or on the principle of legality, not under Paja. Contrary to what has been argued on behalf of UCT, there's no relevant difference in this application between rationality under Paja and under legality. Rationality under legality concerns process, just as it does under Paja, and in the Nurser judgment, paragraphs 48 to 50, one sees the court making this point quite clear. The court there says in paragraph 48, I do not believe that we can separate process rationality and substantive rationality in the way the second judgment purports to. The relevant question for rationality is whether the means, including the process of making a decision, are linked to the purpose or end. To my mind, rationality necessarily, whether found in Paja or anywhere else, must include some evaluation of process. If not, then we are simply asking whether the decision is right or wrong based on post hoc reasoning. And that, with respect, Mr. Justice Henny, addresses also the query that you raised. You can't simply jump to that and say, was that right? Was it the correct moral imperative? It's a natural and inescapable denouement that the process leading to a decision must also be rational. That must be rationally related to the achievement of the purpose for which the power is conferred. Then quotes from paragraph 36 of Democratic Alliance, which I referred to a moment ago. The means for achieving the purpose which the power is conferred must include everything that is done to achieve the purpose, not only the decision employed to achieve the purpose, but also everything done in the process of taking that decision constitutes means towards the attainment of the purpose which the power was conferred. Additionally, in Zuma, NAFTA ADP stated that a rationality review also covers the process by which the decision is made. There's no reason why rationality under Padja should be given a different or more restrictive meaning, and so forth. Yes.
Saying that essentially there is no real difference whether one looks at it under a legality, rationality test, or whether one considers it under a Padja rationality approach, you arrive at the same result.
Say that that is a general
Proposition. But certainly the idea that you can simply ignore process when you look at a rationality review is clearly indicated in the nurse judgment. That's not how one approaches it. One can still take account of that. And we say that on the facts of this case, it would make no difference because we're looking at really fundamental facts. That without weighing those, you can never reach a rational decision because you can never be sure of safeguarding the best interests of the university.
Aspects that were a bit troubling in terms of making sure that they are properly taken account of and are in the right legal boxes. Firstly, the case was argued by your colleagues on the basis that there's a very different test between a rationality and legality review, which requires rational connection, and a Padja review, which, amongst others, talks about whether you've had regard for relevant considerations or not, and whether you've got a duty to consult or not. So that's the start of it. Now, if it's an administrative action,
yes,
then certainly it makes your argument easier because you're saying, well, or does it not?
In this case,
sorry, Mr.
yes.
Again, just to add to that, for your answer.
To add to that, there's a lower threshold. When it comes to rationality review, there's a lower threshold, but as far as I understand, when it comes to executive action.
Judgment and where it quotes from Democratic Alliance, paragraph 36. Yes, it doesn't.
They make that point, but they say there's a lower threshold. My understanding.
Lord, I don't believe that that is correct, with respect.
If you look at paragraph 44, in other words, the definition when the means adopted are rational related to the ends in the executive decision-making cases somehow involves a lower threshold, but not always. Maybe I was trying to say there is somehow involves a lower threshold than in relation to precisely the same decision involving the same process in the administration context.
But what we are dealing with here, bear in mind, is we have a very unusual situation of a university literally jumping over everything that one would normally expect of an organ of state when coming to a decision that may have very significant negative consequences for that organ of state. So that's why we say in the context of this case, it matters not whether one is busy with administrative action or legality review. And the reason for this is because UCT has not put up a subtle case. It's put up a bold case. It has said we have this moral imperative. Therefore, we don't have to weigh, we don't have to evaluate determine what the impact is, what the negative impact is potentially. We can skip over that.
Deviating from where I was asking you, but perhaps can we just go to your colleague's argument? Your colleague says financial considerations were raised by a number of members of council. Questions were asked about it. Clearly, everyone was aware of the fact that it would have potentially some kind of financial consequence. And it is not for the court to start interrogating and saying, well, you should have asked more questions, and you should have attached weight to this and not to that. But before we get there, can we just be clear as to the factual matrix within which we must evaluate this case? Because that's obviously fundamental. Mr. Nkatoibi took us through the correspondence around the 26th of April up to the 3rd of May. And if I may, just with a view to try to arrive at some common understanding of the factual basis in which we must decide the matter. Is it correct that the letters at the time, none of those letters, certainly not from the Donald Gordon Foundation, said, were you to proceed with the resolution before council, that's it, we're going to withdraw funding, we're going to cancel. As I recall, the letter of the 30th of April said this resolution was passed. Well, before that, it said we placed you in breach on the 19th of April because you had, in our view, passed this resolution at council, and this was contrary to the terms of clause 3, which said you were going to follow the IRA definition. But then it goes on to say, well, that's happened, and we need you now as a university to show us that you're going to have zero tolerance for any acts of Semitism. In other words, that you're going to show us you have zero tolerance for anti-Semitism as per clause 3 of the agreement. And he says and suggests, he says, if you read that carefully, it's quite clear that donors were not saying it's done. Unfortunately, you're in breach. The Senate has effectively already breached this agreement. There's no hope unless you now, in council, rescind what was passed or set aside or distance yourself from what Senate passed or refuse to pass this resolution. Otherwise, the funding is gone. Now, that seems to me to be correct. There's nothing there in the correspondence that suggests that there was an imminent threat expressed in writing of cancellation. Then you've got Mr. Orense and the Vice Chancellor's confirmatory affidavit that there were engagements. So they were talking to one another all the way through to the 3rd of May. And again, there's no letter, nothing from the Donald Gordon Foundation saying, we now want to remind you, we told you in the meeting of the 3rd of May, that if you proceed with this council resolution, we will step away from all funding. So there's this engagement process. They're still talking to each other. Yes, there's a pause or some sort of a stop, a suspension of something. They've said to the university that they've already breached the clause, but nowhere is it said to the university in any written letter that should you proceed with the resolution and confirm what Senate did, that's it. No.
Because that's not what triggers the need to disclose. The fact of breach, the fact that now Donald Gordon Foundation, on normal contractual principles, has an election, hasn't exercised the election one way or t'other. You get asked at the council meeting about the potential impact on the university. and it's not disclosed. And I will also take your lordship to the contemporaneous documents and indicate one very important contemporaneous document that was not mentioned by our learned friend, and that's the actual minute of the EXCO meeting. They knew a great deal about threat. And we'll take.
Sorry, he may not have referred to it in argument, but it's certainly dealt with in the answering affidavit. They do deal with it in the answering affidavit, and they say that the Vice Chancellor covered this at EXCO.
They don't understand.
Understanding was if I go there, my lord.
Because this is
Yes.
Me, a very, very important, in fact, vital that we understand this properly, that we have the proper set of facts. Because your colleague says that based on what was there at the time, there was no need to say anything. There was no need to raise anything. There was no real risk because people were talking to each other and it was never said that they would cancel. So,
Yes, you said, and that I think Professor, you also and other members of, it seems, of council, they confirmed that. So the point, so not of council, of the executive, that was. So I'm simply trying to understand what was the council misled on the discussions, because there's a startling and very strong allegation made in the founding papers that all the facts were placed, especially that the Donald Gordon Foundation that had taken a decision before the meeting to withdraw funding. That is on that's the allegation that was made in the founding papers. And council, and they knew about the decision, Mr. Arons and the other parties, and they failed to disclose that.
You'll have to refer me to where it is in the founding affidavit that we say the decision was made to withdraw the funding. I don't recall that.
My understanding was they failed to disclose certain facts with regard to the funding, and that the funding will be withdrawn.
Lord, with respect, and again, the test is not whether it will be withdrawn. The test for disclosure is risk. In other words, there's no need to have certainty about it. What you must ensure is that the council members, when they make a decision, are aware of risk, particularly when the question is asked, what are the potential implications of this? Now, that's a risk question, but in any event, it's what you must weigh up, what you must consider. What are the risks?
Was there any risk at the edge?
yes, my lord. They replaced
In breach.
If you look at the letter of Applebaum,
completely that risk.
Completely, because they've breached and they're now in the period of an election. They haven't exercised their election. They haven't said, no one has said from the Donald Gordon Foundation that we have exercised an election to keep this contract alive, notwithstanding your breach. So they're in the period of election, and I will take the court to that. I'm going to ask an indulgence from your ladyship, which is we do cover all of this. It may be quicker, I'm just raising it as a matter of speed, maybe quicker if I do go through my heads and where these points arise, questions get addressed, I'm maybe taken out of sequence, and it may just be faster if I do it that way. Yes. Yes.
That the moment they were placed in breach, there no longer was a need for a further warning that, oh, this is what we're going to do, because we're not dealing here with people who would not have understood what it meant to be placed in breach. They understood the risk that attached to being placed in breach. So therefore, the donors need not have said that if you don't do this, we do that. This is the nub of your argument.
So still under the first reason, we say that a failure to take account of relevant material constitutes a failure of means to achieve the purpose for which the power was conferred. That's the NERSA point. So it's an entirely procedural question, and in this application, we have nowhere strayed from that. This is a challenge to the process. We agree with UCT that 3 questions inform the determination of whether a failure to consider relevant material renders a decision irrational, and I've sought to show the court that we've addressed all 3 of those questions in our heads of argument. And we proceed to consider now each of these under our second reason for why UCT's defenses do not withstand scrutiny, and that's then our heading rationality and adverse impact. As to the first question, adverse consequences, including financial and reputational impacts, were relevant to Council's decision, and we had understood this to be conceded by UCT in its papers and heads of argument. If I might ask the court, just as an example, to go to paragraph 12 of our learned friends' heads of argument. So impacts are relevant. That's what they say there. So what our learned friend argued, therefore, on his feet is not quite the argument that was made in the heads of argument, where it's accepted that consequences were relevant. And our learned friend, having initially taken the view about the moral imperative of making any investigation into the costs and benefits to UCT irrelevant, did seem to move away from that later on. And in any event, there's absolutely no room for such an argument in our legal system. And in my opening address, I did refer the court to the COVID-19 judgment in ESAW. More specifically, item 4 of the implementation manual, which is at the back of the regulations for reporting by public higher education institutions, which has been handed up to the court, which is made under the Higher Education Act, includes in the responsibilities of counsel to understand that strategy, risk, performance, and sustainability are inseparable, to be responsible for the governance of risk, to ensure that there's an effective risk-based internal audit, and once again to act in the best interest of the university. It's all there in the regulations. Our learned friend accordingly did go on, as I say, his argument moved away from that initial stark position, went on to refer to the benefits to UCT of adopting the resolutions. Our learned friend was scornful of our employment of the term cost-benefit analysis. But as soon as you go to the benefits to UCT, you're also looking at a cost-benefit analysis. The problem here is that council decided to do a cost-benefit analysis without examining the cost side of the equation. Council decided not to consider negative impacts, including financial losses and their impact on staff and students, before passing the resolutions. The court will see in file 3B the transcript of the meeting at 681. 681, my lord. Where the chair says at line 3, this speaks to our values, this speaks to our commitment to social justice, and then an unnumbered speaker says decisions have consequences, chair, and the speaker then and then speaker 1, the chair says, but that is a different consideration, and then goes on to say we can't be held to ransom. That's a different consideration, but with respect, it is the very consideration that had to be performed. Ms. Mohammed described the implications for the university as dense and opaque. This is at page 694, near the top of the page. One cannot see through what those implications are. But that's because no examination had been undertaken of what those implications might be. There is a tension in UCT's case. On the one hand, it contends that consequences are irrelevant because of the moral imperative, and on the other hand, it was argued that UCT considered adverse consequences but afforded them no weight. So without taking the court there, at paragraph 417 of the answering affidavit, which is in volume 4A at 1137, the chair says that whilst no assessment was done of the cost implications of the resolutions, this does not mean that council was not aware of the potential financial, relational, and reputational implications. So that aligns with the argument consideration was given to consequences, because consequences were mentioned. But our respectful submission, and this is crucial, is that that is wholly insufficient. And we, with great respect, would align ourselves with the question that was put to our learned friend by Mr. Justice Scher, based on the hypothetical example of a medicine where the body, considering whether to approve it, mentioned that it may have adverse health consequences and leaves it at that. It does not consider whether the consequences are a mild allergy or anaphylactic shock resulting possibly in death. The only response from our learned friend was that we are not dealing with a hypothetical case, but one raises an hypothesis in order to test the principle. That's why courts do this. This is why lawyers do ask these questions. And the hypothetical example in our respectful submission is on the mark. UCT was not deciding between stopping a genocide and losing funding. Those weren't the alternatives here. It accepts that the resolutions would have no impact whatsoever on the war in Gaza. It was making a reputational decision. So it undoubtedly needed to consider whether the resolutions would make UCT better or sicker, and if sicker, then by how much. It needed to consider whether by risking the loss of substantial funding, UCT would be able to retain its position as the top-ranked university in Africa, or in a worst-case scenario, continue as a university. This needed to be considered. That was the best interest imperative. The process, as the court said in NERSA, must be rational. And it's not rational to recognize that there will be adverse impacts, as the chair testifies. There will be adverse impacts. And then to proceed to make a decision without knowing anything at all about those impacts, including, as I said in opening, the order of magnitude of the loss of financial support, how many students would lose funding, which we know just from the Dell Foundation was 288, just from the Dell Foundation, and how many research projects would have to be terminated and how many staff members would have to be retrenched. In Clarison's, it was raised from the bench, the SCA said that it's for a functionary to decide how far a particular factor affects the eventual determination of the matter. But it's impossible to know, absent any investigation, how far the factor affects the decision. And again, going back to what was raised by Mr. Justice Scher, how does one weigh up considerations when nothing is placed on the scale? It's not that council did not afford the negative impacts on UCT too little weight. That's not our case. That we can't make that case. It adopted an a priori position that the combined weight of all those negative impacts, whatever it might be, was irrelevant. That's then the first question. As to the second question, informing the determination of whether failure to consider relevant material renders a decision irrational, the purpose of council's power is to govern in UCT's best interests. So it passes resolutions as part of its governance of UCT in university's best interests. A striking aspect of our learned friend's argument was his avoidance of the term best interests. That is the operative statutory provision for the purpose of this application. Mr. Arendse, in fact, admitted, and he really had to admit this, that council could only pass the resolutions if they were in UCT's best interest. And I don't believe I need to take the court there, but it's paragraph 418 of the answering affidavit, 4A, page 1137. What is made plain in the ETV judgment, paragraph 76 to 78, is that council could not decide whether the resolutions were in UCT's best interests without considering the adverse consequences for the university. The failure to consider these consequences as a means bears no link taking a decision in UCT's best interests. Then as to the third question, a central feature of acting in the university's best interest, and that's in line with what was said by the Constitutional Court in paragraph 78 of ETV, is to mitigate adverse impacts on the university. A process that failed to consider that adverse impact is inevitably colored with irrationality. How do you mitigate impacts if you don't know what the impacts are? And the fact that the resolutions were taken for a moral purpose does not remediate the central irrationality of failing to consider adverse consequences. And what we should perhaps stress, because this was raised from the bench, this is not merely a pothole on the way to deciding whether something is in UCT's best interest. The failure to investigate adverse or negative impact in order that consideration could be given to how best to mitigate those impacts is the end of the road. It renders the decision irrational. That's the law. I turn then to the third reason, the failure to consult. I've referred already to various allegations in the founding papers pertaining to council's failure to consult. Rationality imposes a need to consult, but there was also a specific legal duty to consult, because clause 7.1 of the risk management policy, and again, I don't believe the court needs to go there, but the reference is volume 3B at 888, binds council to the standards of good corporate governance in the King IV guidelines. The King Code is also applicable to council by virtue of the implementation manual. UCT denies having failed to comply with those standards, and again, just the reference. Paragraph 663 of the answering affidavit, volume 4A at 1201. But it has failed to comply because King IV requires of council that it adopt a stakeholder inclusive approach and consider the needs, interests, and expectations of material stakeholders. Item 4 of the manual includes in the governance responsibilities of council to appreciate that stakeholders' perceptions affect universities' reputations. Bearing in mind, the university has a reputational point that it raises. The Council failed to consult with any of UCT's stakeholders before taking these crucial decisions. We know who the stakeholders are because Council has told the court. It has said at paragraph 46 of the answering affidavit, at page 980 in volume 4A, that the stakeholders include academic partners, staff, both academic and professional, students, the government and government agencies, the private sector, civil society groups, parents, funders, and the media. Council's failure to have consulted with any of these stakeholders renders its decision unlawful on the basis of legality. Additionally, the failure to have consulted with stakeholders, particularly those affected by the resolutions directly, including, as our learned friend Ms. Adhikari pointed out, Jewish stakeholders, renders the process irrational. It is similar to the case of Albert, one of the judgments that we handed up, where the President's special dispensation process for people convicted of politically motivated offences was held by the Constitutional Court to be irrational without the participation of the victims of the crimes. They were entitled to be heard. Here, two stakeholder views were relevant. That's the first question. There's no link between failing to consider those views and acting in UCT's best interests. Second question. And again, if the purpose was to combat anti-Semitism, the views of Jewish stakeholders were crucial. And the failure to consider stakeholders' views colors the entire process with irrationality. The third question. There's nothing that mitigates this irrationality. A moral imperative cannot mean that you do not consult people. You could, for example, only achieve the ostensible imperative, that of combating anti-Semitism, by speaking to Jews. You could only prevent complicity with genocide if you spoke to those academics who work with Israelis. It does not, with respect, assist Council to say that it has representatives from various constituencies among its members. There's no evidence to suggest that the union members on Council had canvassed with their membership, whether they're content that there should be staff retrenchments, if that should be the case. There's no evidence to suggest that the student members of Council had undertaken any process to ascertain the views of students about the impact on them of losing donor funding. The impact would be felt, and this is the 2019 Impact Assessment Report made clear, by Black students, goes to the transformation concerns at the university. In 2019, Council consulted, and it consulted very widely, and the deviation from that process in 2024 has not been justified. This was after the Mpati report had carefully explained the failure of governance at UCT. The only justification one finds is urgency, but that cannot be correct. It is now 16 months later and was submitted on behalf of UCT, and the resolutions have not yet been implemented. We shall explain below that the submission is wrong, but the point here is that it undermines Council's purported reliance on urgency. There's no justification not having followed a consultation process at all. The fourth reason, fiduciary duties. Council members owe fiduciary duties to the university, including the duty to disclose material information.
Advocate Kazi, if she is still in. Advocate Kazi? Advocate Kazi, can you still hear the proceedings?
She did.
Okay, thank you.
Council members owe fiduciary duties, and I've shown the court where at
Advocate Kazi, are you still able to hear the proceedings?
My lady, I am. I was accidentally boosted out, but I've been let back into the system. Thank you so much.
Okay, thank you.
council members owe fiduciary duties to the university, and as we have shown, Mr. Arons admits this at paragraph 475 of the answering 375 of the answering affidavit. This includes a duty to disclose material information. In the first place, this is an objective question. Did the chair and exco know material information, and did they fail to disclose it? If so, there's a breach of fiduciary duty. The reasons for non-disclosure do not in the first place matter. But this case does not end there with respect. The evidence in this matter demonstrates, we submit, there was an intention to conceal evidence from counsel. It's unnecessary for the purpose of finding a breach of fiduciary duties, but the evidence shows there was a deliberate non-disclosure. We stress in this regard, and this is a point that perhaps got lost in the debate with our learned friend, non-disclosure is a subset of the contention that counsel acted irrationally by failing to take account of what it needed to do, the considerations that bear on its decision. So if, in other words, even if the court should find that the chair and exco subjectively believe that it was unnecessary to disclose the suspension and the risk of termination of donor funding, the objective fact remains that council adopted these resolutions in an information vacuum.
Deliberate. From the facts, where can we discern the deliberateness of the whole thing? Okay.
Our learned friend took the court to what he said were all the contemporaneous documents, but he omitted the most important such document, as I said to the court earlier, which is the minute of the EXCO meeting of 23 May 2024. And that is in volume 3A. 3A at page 439, and what is relevant is at pages 445 to 446.
445 and 446.
445.
It's discussed at EXCO. At the foot of 445, the chair drew attention to a meeting with the Donald Gordon Foundation, who had committed a large donation to the Neurosciences Institute project. The Vice-Chancellor told EXCO that Hilton Applebaum had written to the Chair of Council and himself in the wake of the Senate's resolution pertaining to the academic boycott of institutions and individuals involved with the Israeli military, and at once indicated that UCT was in breach of the agreement. That's the fifth line at 446, my lord. In as far as the agreement contained a clause stipulating that UCT shall adopt a zero-tolerance attitude to anti-Semitism, and two, suggested a meeting to discuss the types of measures UCT should be taking. The Vice-Chancellor had responded by informing them what he had in mind, seeking avenues for engagement with the university community, and suggested it would be appropriate to wait until after the election on 29 May before proceeding. He indicated further that the Dell Foundation indicated very soon after the Senate meeting that it would be suspending funding to UCT, so that too was known. Members made the following inputs. They cautioned the university against manipulation by funders that had a pro-Israel stance and not to sacrifice its principles for funding. Spoke about donor power and donor privilege, noting that it was perfectly in order for donors to expect institutions to which they donated to live up to certain values and behaviors. It was unacceptable to use a single issue to exercise power in a way that was disproportionate. and suggested that UCT should subscribe to the Jerusalem Declaration. Then the chair informed EXCO that no decisions were made that were contrary to the values of the university, emphasized the importance of keeping discussions going, and that the resolution adopted by the Senate, and I'm going to stress this, would only become the university's official position if adopted by council. So the chair said to EXCO, there's a further important step. This is an important step. So what was known to the chair and EXCO is, firstly, the donor agreement required UCT not to reject the IRA definition. Secondly, Senate breached the agreement by passing the first resolution. Thirdly, that would become the university's official position if the resolutions are adopted by by council. Donald Gordon Foundation placed UCT in breach on 30 April 2024. It knew something else. It knew that the Donald Gordon Foundation was very critical of the Jerusalem Declaration, because there's an aspect of the letter of breach that our learned friend did not take the court to. If I might ask the court to go to 4C. At page 1792, 1792. The letter of 30 April 2024 starts on the previous page. Volume C. In the middle of that page, Applebaum wrote this: the Jerusalem Declaration has not demonstrably helped the fight against anti-Semitism. Most egregiously, it has a blind spot for anti-Semitism that originates on the political left, precisely the form of anti-Semitism most common in South Africa. The Declaration allows Israel to be labeled as a unique exemplar of settler colonialism and apartheid, gives a pass to those who claim that Israel has no right to exist. Next paragraph, it marginalizes distinctive history and features. And next one says it's clearly flawed in its analysis. It's not a question of whether it's right or wrong, what Mr. Applebaum says. The point is the Donald Gordon Foundation made it clear it doesn't like the Jerusalem Declaration in substitution for the IRA definition, and this was known to EXCO. We know something more. According to the email from Professor Fegan in volume 4B at page 1568, the Donald Gordon Foundation was considering to terminate the contract. One sees in the second last paragraph on that page, major concern is that in rejecting the IRA definition, which is specified in our donation agreement, UCT would be in breach of contract, and the foundation is considering withdrawing on that basis, which would be disastrous for the Neuroscience Institute. This too, therefore, was known to EXCO and for UCT more broadly, as we are also in discussion about what may be an even larger donation to support UCT private academic hospital. Mr. Arons, in his rejoinder, refers at paragraph 302, volume 5D, at page 3261, the following, Professor Mendelsohn, sorry, 3261, says Professor Mendelsohn says that EXCO discussed manipulation by funders, and the fact that this was discussed indicated that EXCO understood the DGF to have made a legitimate threat to cancel the donor agreement. That is so. He confirms that EXCO understood that the Donald Gordon Foundation made a legitimate threat to cancel the donor agreement.
In other words, in this section, Madam, whereas you are saying this is where we can draw the inference of deliberateness, because it should
The leadership does not need to draw that conclusion, but the leadership can draw that conclusion. In other words, it's sufficient for us that relevant information was not disclosed, but we say it goes further. This shows an intentional non-disclosure. Just on Professor Fegan, I'm not sure why our learned friend referred to Professor Fegan as a donor representative. He clearly was not. He was a recipient of a potential donation. I've shown the course that what the EXCO also knew is that the two resolutions imperiled the donation of a private hospital. About the risk of losing a private hospital, which is obviously an enormous donation, our learned friend said only this, that the private hospital features only once in the contemporaneous correspondence. I've shown the court where it is. But with respect, how many times does it need to feature? Once is enough. Yes.
I think it is important just to point out that in the papers, they say, no, there were talks, it was an exploratory phase, they hadn't even got to putting up a plan, so it was all very much pie in the sky. It was possible, but nothing concrete, nothing reduced to a budget, nothing reduced to a financial statement. So you know.
So again, we're talking about risk.
Yeah.
So you had a potentially
massive reward. There was a risk, there was a potential for that reward to be achieved by the University of Cape Town. The university tends to try to underplay that. They tend to underplay what the value was of this hospital, and they tend to underplay the stage it has reached. But there was no contract as yet. But there were working groups, there'd been a visit to Johannesburg, real concrete steps had taken place, and one can see Professor Fegan was hopeful of actually getting this hospital, and we know from the papers that actually has gone to Stellenbosch University. So to that extent, not pie in the sky. But again, just on the risk basis, you ask about potential implications, and a potential implication was that a hospital that UCT may get, it's not going to get.
the link was made by Professor Fegan.
The link was made by Professor Fegan. It may not have been said in any of the letters of the Applebaums, but certainly as Professor Fegan understood it, he says in his response, not only is there the loss of the Donald Gordon Foundation's donation, but also the private hospital. And he says it's of some value. Yes.
In other words, our learned friend is correct that that's the only reference to it in the contemporaneous documents, but our submission is that's a risk. That is sufficient, more than sufficient indeed, to require a disclosure. As for the Dell Foundation, again, on contemporaneous documents, the chair and EXCO knew that the Dell Foundation had suspended funding after Senate passed the resolutions. And this appears again from the EXCO minute, to which our learned friend did not refer, and I've shown the court that. In the case of both donors, in fact, if I'm maybe just ask the court to go there, in volume 3A at 446. When EXCO discusses manipulation by funders that had a pro-Israel stance, and I've shown the court that, this means they understood that donors were concerned about the two resolutions. They don't agree with donors' stance, they don't think they should take this position, but that's irrelevant, because again, it's a matter of what must be disclosed to council, so that council members generally know the same as EXCO members know. That's really what one's looking at. Why should there be this difference? EXCO is a subcommittee of the council.
Especially considering that they have the Senate minutes.
Yes. Yeah.
All they had was the two Senate resolutions. So that's a bit scary to think that decisions were taken on the basis of two documents only. The two Senate resolutions, nothing else.
Yes, exactly.
Absolutely all they had. Yes. Yes. On the same page of 446, the third bullet point, they suggested UCT should subscribe to the Jerusalem Declaration. This is in the context of knowing that the Donald Gordon Foundation is unhappy about the Jerusalem Declaration. So they're taking a decision, or they're expressing a view which they know to be adverse to what Donald Gordon Foundation's position is. Again, it's not for the court to decide whether that's right or wrong. That's not the relevant question. But it's, as it were, saying, let's create this risk, or let's as it were, exacerbate this risk.
That's entirely correct, because your colleague referred to an email where Professor Fegan, I think it was, said, well, they're encouraged by Professor Mendelsohn, or Professor Mendelsohn has expressed encouragement, positive, seen it as a positive that they would adopt the...
No, Fegan.
Was it Fegan?
Fegan. It was Fegan.
So Professor Fegan, I think, or somebody thought that Professor Mendelsohn thought it was a positive to accept the Jerusalem Declaration. So that's in writing.
So your Lordship is, with respect, correct in saying that is an additional fact. But you had the letter of breach from Donald Gordon saying we are unhappy with the Jerusalem Declaration. The only point is not where are you going to come out on the Jerusalem Declaration, but what was council entitled to know? Why should council not also know that Donald Gordon Foundation doesn't like the Jerusalem Declaration? So EXCO understood that the donors were concerned about the two resolutions and understood that the two resolutions created a risk of losing the donations. That allegation is in fact confirmed by the then Vice Chancellor, Professor Reddy. That's his rejoinder, paragraph 19, volume 5E at 3640. Sorry, Professor Reddy's rejoinder, paragraph 19. In fact, if your Lordships would go in the note that we handed up to footnote 26. Then the court will see that what is said by Ms. Phelps in paragraph 24 at page 204C volume 4D. Only in response to questions later in the meeting about whether the interim VC was concerned for the university in light of the ambivalence he had encountered from donors in the wake of the impugned resolutions, did he reply that he believed that he did represent a risk, especially in the case of the donations by DGF and Dell, and that is confirmed. In a paragraph of the rejoinder affidavit of Professor Reddy, which we reference in footnote 26. We also refer to Mr. Perumalsami's affidavit about EXCO being aware of the funding threat. That is same volume 4D at 1922. Paragraph 162. It refers to the second member. This is an EXCO member. Challenged the assertion that only 5 council members were aware of potential funding issues, arguing that the impact on the DGF funding was discussed prior to the resolution decision. He believed that the news of the funding reconsideration spread quickly throughout the university, suggesting that many council members were aware of the funding threat. So despite being asked repeatedly about potential implications, the chair and EXCO failed to disclose these known facts and risks at the meeting of 22 June 2024. What UCT argues, what our learned friend argued, is that because there was no clear threat to cancel the donations, if council passed the resolutions, the chair and EXCO did not need to disclose these known facts, but our submission with respect is even if there was no clear threat, on a complete and proper reading of all the contemporaneous documents, there was plainly a material risk of the 2 resolutions causing UCT to suffer loss. And our submission is simply that the chair and EXCO, as bearers of fiduciary duties, had the obligation to disclose those known risks. Also, and this is of importance as well, both the Donald Gordon Foundation and the Dell Foundation allege that there was a clear threat to cancel if council passed the resolutions. And we've been through this about initially the version being there was no recollection on the part of the chair and the vice chancellor of this. But there's with respect no reason to doubt the version of the donors. It coheres with the contemporaneous documents, including the email from Ms. Archer, who describes the Dell Foundation's decision to cancel its direct funding partnership with UCT as momentous. So Ms. Archer describes the Dell Foundation's decision to cancel its direct funding partnership as momentous. So it was known to Ms. Archer, certainly, that the Dell Foundation had cancelled, and we know from the contemporaneous documents that the suspension of funding was before the EXCO as well. Yes.
Find in favor of the donors.
We have contradictory versions from the chair and the vice chancellor. And there's a further point. Why would the donors, and this is a relevant factor, why would the donors mislead the court about this?
In respect of what of the donors are you referring to?
Go to volume 4C, 1783. 4C, 1783.
Was it paid?
1783, my lord. Paragraph 9. Mr. Arendt's allegations are false. There was no uncertainty with regard to the DGF's position. Yes. Mr. Arendtson knows the allegations to be false.
The argument is that it was on is there confirmatory affidavit to this?
Also on 3 May 2024, paragraph 13, the DGF met with Mr. Arendtson and informed him in clear terms that the council endorsed the resolutions and rejected the IRA definition. DGF would cancel its contract.
This was Mrs. Applebaum. Mr. Applebaum.
Bear in mind, all of this comes against the backdrop of a situation where
Of this not having to accept that a senior counsel, many years experience, who's occupying the position of chair, deliberately, effectively lie. I mean, that's what you're saying.
indicated earlier in my opening address, this case has been run on a very unusual basis. We have now this latest affidavit from Mr. Arendtson. For instance, it shows in the first place a census. It was UCT who filed the affidavit by Professor Moultrie. And then a week later, UCT files another affidavit by Mr. Arendtson to take issue with what was said in its earlier affidavit. But that's at a census point. And this is about...
I know you were busy answering, but to get back to the question of Plascon Evans, we have the version of, or at the very least, what you're saying here is following. In respect of this particular letter of Obama. And you say that we should refer the letter of the donor beyond, in other words, above that of Mr. Arendtson.
With respect to and to this,
And on what basis?
there are two versions, and this is the second version.
So we must make an evaluation of what evidence in respect of this specific point we should accept. What you're saying. Are we permitted to do that?
Because the court can make decisions. In other words, if a witness on oath, on affidavit, gives the court two different versions. But the first version was, I cannot remember. And the second version is based on memory. That matters.
You know, just to go to the letter of the Donald Gordon Foundation, paragraph 13, it is alleged that at the meeting they informed Mr. Arendtson in clear terms that if council endorsed the resolutions, I'm reading from the letter, and rejected the IRA definition, the Donald Gordon Foundation cancelled its contract of donation of 200 million. So are you saying that, having been told this in clear terms, is it probable, likely, that any advocate, let alone a senior counsel, who's also the chair of the university, would not disclose this at a council meeting when the topic of financial implications is raised? Are we saying deliberately would not, knowing the risks to his reputation, to the university, all the rest? That's quite a serious.
The other issue is if one should go that route, then one should go on the process of evaluation of what was said. And then on the other hand, you look at the evidence and the correspondence referred to by Mr. Ngatobi. And then about Mr. Arendse saying, look, at that stage we were in genuine negotiations. I think Professor Reddy was the person that spearheaded that. We were asked to give assurances that Jewish students and staff would be. We knew and we are aware of what happened in the Senate about this. We're not happy with this IRA definition, but notwithstanding that, we are able and we will be negotiating with the university further in this regard. That's on the one hand what Mr. Arendse says. And then on the other hand, you have this very strong statement in paragraph 13 of the Applebaums saying that, no, we definitely, in no uncertain terms, what's the words there? Made it clear that if council endorsed the resolution in Gaza and rejected the IRA definition, then the DGF would cancel its contract of relation of 200 million rand. And then we also have the letter which that was referred to. So we will then have to make a decision on this, because this would mean that more than a month before the council meeting of the 22nd of June, Mr. Arendse and the rest knew about it, failed to disclose it, and he lied to this court.
Taken the court to the word threat. So definitely Exco was alive to the threat.
Alive to the threat? By saying, but by him saying that was not the position. And then we will have to put everything in the pot. Also the Applebaum letter, the affidavits of Professor Reddy, and the other people that were involved, because it's not just a matter of beginning with what Mr. Arendse was saying and what Ms. Applebaum was saying. And you have to want us to make on in motion proceedings come to such a drastic decision. I don't know if we are permitted to do so, unless we apply, as I think my colleague pointed out, Basford Evans, what's the other case came from this photo?
Edmund Whiteman.
Yeah, which justice it came from this to the ACA. Whiteman, yeah. And as far as I'm concerned, unless if we apply the test in Glasgow evidence, but Mr. Arendse says he is far-fetched, cannot be believed, and it is of such a nature. In other words, we need to merely make some finding along those lines, as I said it in Wickman and in Mike, I don't know how you pronounce it, or and plus Evans.
Purpose of the merits of the case, but it goes to our costs argument. The purpose of the merits of the case, bear in mind, this is about the question of whether, about UCT's argument there was no clear threat to cancel. And whether there's a,
My colleague Justice said we need to find the factual matrix under which it is. We clearly need to find what's happened there. What is the factual matrix? Because there's some factual matrix portrayed by the respondents, and then there's the other fact, and we need to deal with that.
there's two donors, the Dell Foundation as well. We have Professor Reddy saying, I don't remember. We point out, well, here's our versions. Then we have a reconsideration.
It doesn't say that. It says the donors met with Mr. Oren.
The Dell Foundation.
Sorry?
The Dell Foundation.
No.
So
There's Professor Reddy and Mr. Orange, so both who talk about not remembering and then changing their version.
Yes, but Professor Reddy cannot corroborate what happened at the meeting of the third.
No, not
not the
Yes, but that's what we're
the third
asking.
of it, yes.
So
But with this respect, it's relevant that there are two donors we're talking about. Yeah. No? Yeah. Yeah. So you've got two donors saying we warned you. You've got two deponents on behalf of the university saying we don't remember. And then subsequently changing their version.
The cluster events. I think that the real question that should be asked here is whether the ongoing discussions the parties had sort of had an impact that justified the non-disclosure. We know that the terms of the contract with DGF was around the iron, and that's not negotiable. We know that. Now, whether those further discussions mitigated that, that's the question we are going to have to answer.
yes, because sorry, on that point, as Judge Ndita has asked you, in the answering affidavit, they say they were assuaged. Any concerns they had were assuaged by the fact that there were engagements and they were talking to each other, and they thought, well, we're not at risk really. We're talking to, they're telling us they're talking to us. We're going to have meetings. We've spoken to each other. Even Professor Mendelsohn, they say, was happy because he may get the Jerusalem Declaration.
I've shown the court where Professor
Confirm that there was in his affidavit. So there can't be a question about whether there was risk with respect. We're addressing here the question whether there's a clear threat. And that with respect is a question of nuance, but it never addresses the main question, which is that there was a failure here to disclose something that should have been disclosed because of the risk. May I test it this way? What the court finds in this case would apply to any organisation.
And it's difficult to maybe to understand what went on in the mind of Mr. Arons or the members of council. Are you saying that there could not have been a belief on the part of the members of those executive members, including Mr. Arons, that they were at risk that these agreements or contracts of the nation would be cancelled?
You want the evidence that
Risk, Professor Reddy has confirmed that.
No.
So that doesn't, that with respect doesn't go anywhere. It wasn't disclosed. Known risk wasn't disclosed. So that kind of closes that question. Now, that's not on the papers, that's not in dispute, at least from Professor Reddy. He confirms that there was known risk. And we can see from the papers that a threat was known to Exco. So that's not actually a fact in dispute. Then the question is only, should this have been disclosed? And our submission is clearly, and may I test it this way? What this court finds here would apply to any organ of state. And our submission is it's unimaginable that any court would say, for example, that the mayor of Cape Town does not need to disclose to the municipal council that the city has been placed in breach of a 200 million rand contract and is at risk of losing that money should the council adopt a certain resolution, even if there are negotiations to try and remediate that situation. In fact, what negotiations indicate is risk. That's why you negotiate. You're trying to deal with risk. So for an organ, we're talking about organ of state here, University of Cape Town, but that's the test. Or Transnet. You can't not disclose these kinds of risks. And again, I come back to the point I made earlier. On what basis do the members of a subcommittee of council, the EXCO members, say, sure, we have this knowledge, but we're not going to tell our fellow council members this, despite their asking about potential implications? That cannot, with respect, be correct in regard to any organ of state.
Governance, not with the ultimately lies with council.
Absolutely.
As your lordship pleases. If I may then turn to the fifth reason, mootness or curing. Yes.
I find anywhere, and I may not have looked properly, but in the almost 300-page, I went through it again last night, and I couldn't find in express terms that pleaded the case about the institutional statute and the reconsideration. Effectively, it's moot because I couldn't find any of it.
In fact, Lord, on that institutional statute we attached to our papers, but we didn't even attach section 20. It wasn't relevant to what we were trying to say. And it's not attached to UCT's papers. And our learned friend very fairly said he was told about this during tea time. So, and he had the wrong section initially, 25H, and actually it's 20 sub 5G. I think that was that he had in mind, but it's nowhere there.
Pleaded part of the pleading case.
It's a factual question. So there are circumstances
Where courts can raise mootness, but it's got to be on the papers. And in other words, the facts going to that have to be on the papers. And this argument that was made was detached from anything on the papers, as your lordship points out.
As you pointed out correctly, the question of mootness falls away for two reasons. The one reason is that the decision of the 24th was never rescinded. So the question of the 22nd of June then still stands. If that is what you're saying.
Yes. That's what your lordship said earlier.
It was looked at 20 sub 5 in the meantime. And what that is it's just saying, if you want to rescind within a certain period, this is the process. That's all it is. It's just a process provision. So it's not a revisiting of the decision in the sense of, are we going to adopt this decision again? It's just saying, are we going to rescind it? Because someone has said, let's rescind this decision. It's a very different issue. We have also pointed out that in the papers, Mr. Arends says whatever happened after 22 June 2024 is not relevant. In fact, the bench also asked that question of our learned friend for one of the amici. For Ms. Phelps. What's the relevance? She wasn't there on 22 June. So what does it matter what happened afterwards? And with respect, that is a correct question. So Mr. Arendse, and we've given the references, did not set out to mislead us by saying what happened after 22 June is not relevant. It wasn't considered by UCT to be relevant because they didn't think what happened on 15 March could render anything moot.
Just as an aside, it cannot just be procedural question, the question of mootness for the point of mootness. I said it in this document, the institution statutes. I think one must give a proper interpretation to it. Why would they put that into the document if you don't have the power to rescind? So.
The power to rescind is there, but it's a power to rescind, and then you can reconsider, then come up with a fresh resolution, and you consider whether to adopt that or not. It's really, we believe, more a curing issue than a mootness issue, but that again has not been pleaded. That is factual. Curing is very seldom recognized in our law. We have in the little bundle handed up to the court 2 pages from Hoekstra and Penfold where they make the point. They say it's can never be raised where there's bias or procedural defects, and in this case we say there is both. We've also referred to a very recent judgment in this division by His Lordship Mr. Acting Justice Farlam, the case of Maki Investments. It's also in the bundle. And what he says there's curing is a factual question. We have in our note referred to relevant pages. From that judgment, that's in footnote 35, relevant paragraphs from that judgment. And because of the factual nature of curing, it was necessary for UCT to plead this. Our learned friend described the decision of 15 March 2025 as self-correcting, as initially with reference to section 20 sub 5, paragraph 8, but later corrected to 20 sub 5G. That says nothing about correcting a decision. There's also this: if a vote not to rescind is to be regarded as a fresh decision, which you now have to take on review, that immunizes the council from review. Every time you bring a review application, they say, well, we'll consider whether or not to rescind it. They don't rescind it, and then they say, oh, now you've got to start again. You've now got to deal with our new decision. There's no substance to this. All you're doing is you're keeping alive your original decision.
So a proper meaning must be ascribed to the word rescission. And rescission can only be a real rescission of a decision, saying, look, we've done this. And rescind means, what's the ordinary meaning of rescind? We've made a decision. Does it mean we're changing the decision, or what does it mean?
Actually, it can only mean set it aside in its entirety, or don't set it aside in its entirety. That's all it is. And
how we are to rescind it, to set it aside. In the same meaning as setting it aside, refer back and make a new decision.
it's a sensible provision, because otherwise you have the difficulty of having to approach court to set aside a decision. So now you build it in, you give yourself the power to do that, or you get given the power to do that. And you can set it aside yourself, as it were. You rescind it yourself, and then you can go through the process again. But there's also just on the fact
to rescind, and then a formal decision to rescind and replace. Okay.
So the decision to rescind, which must be carried to get rid of the old decision, and then you take a new decision. And what's important here in any event is that council still did not consider all relevant considerations. It knew more than it did at the previous occasion because it had the benefit of the founding affidavit and supplementary founding affidavit. Yes.
In minutes of that meeting,
I believe we have the minutes.
of that decision.
We have the minutes of that meeting.
To describe what Mr. Perrin was saying, what
Happened there, but the minutes aren't there. And with respect, your lordship's question is a good one. If UCT had intended relying on this, why wouldn't they have attached the minutes? So what we say, and this is in paragraph 28 of the note, when deciding whether to rescind, council did not consider EXCO's reasons for non-disclosure, the DGF's, the Donald Gordon Foundation's breach letter of 30 April 2024, the cancellation letter of 6 August. None of that was there because none of this was annexed to Professor Mendelsohn's papers. We didn't have these documents. Professor Fegan's email of 26 April was also not there. And still there were no views of stakeholders. There was no updated impact assessment report, and they didn't have any legal opinions. They didn't in particular have the bishop opinions. Yes. So there was simply no reconsideration. It was just a decision whether to rescind or not. It's also described as not the best of meetings. In other words, it was conducted in a very unpleasant atmosphere, not the kind of atmosphere where you're looking constructively to, are you going to adopt a new resolution? It was all about, should we set this one aside or not? And that was the end of it. Then on ripeness, again, it's not pleaded. We have the contradiction and therefore the difficulty that's raised by His Lordship Mr. Justice Cameron in the judgment we referred to. It's not pleaded, but it's not even referred to in UCT's heads of argument. It's another afterthought. It's also, we say, secondly, an attempt to retrofit reasons for the decision. The texts of the resolutions imply immediate force and effect. There's nothing in them, and I think this point was raised from the bench with our learned friend. There's nothing in them about first formulating guidelines for implementation. I think our learned friend's eye fell on something in a letter from Mr. Applebaum, who refers to guidelines. Those are completely different guidelines, not these guidelines. Those. Third, as a matter of fact, Council voted against suspending the implementation of the resolutions on 27 July 2024. That contradicts the allegation they were not yet ripe for implementation, and it's unexplained. And the court will recall that UCT relied not only on the March 2025 meeting, but also on the 27 July 2024 meeting.
Yes, with no decision.
That, sorry, maybe I misunderstood. They voted against suspending implementation on 27 July, as your lordship pleases. Yes. So it's a vote to implement. But also, the court will recall that our learned friend relied not only on the March 2025 meeting, but also on the 27 July 2024 meeting in support of the mootness argument. And that could only be justifiable if it were a final decision. In other words, can't have mootness otherwise. So it contradicts. Fine. Fourthly, as a fact, we know from the papers that UCT has implemented the second resolution because there was that meeting or conference to which Israeli academics were invited. We have the reference in footnote 43, and we make the further point that the chair does not deny the resolution's implementation in his rejoinder. So this is very much an afterthought. Fifthly, the argument effectively concedes irrationality because UCT says further steps have to be taken in order to understand the full meaning and consequences of the two resolutions. The Senate will now apply its mind to this. So irrationally, they've passed resolutions in the best interests of the university without knowing their meaning and the sanctions for breach. And just on that, it surely matters to a rational decision maker whether the penalty for breach of these resolutions is a small fine or summary dismissal. It's surely something that must weigh with a rational decision maker. So it's not a matter of an elastic policy. The core parts of the resolutions are vague and not understood by counsel, such as what does broader military establishment mean? Sixthly, it's irrelevant to describe the resolutions as policy because there's no magic in the term. These are operative provisions. One knows that policies may be documents under which further decisions are made, and those are operative provisions, or policies can themselves be operative. And the court will bear in mind that in the Gelyke Kanse case, what was being challenged there was policy. And the court didn't say you can't challenge policy. Yes, prior to implementation. So these provisions are not dependent on a further step to come into operation. We know they're operative because they've been given effect to. They've been used in respect of that conference. Seventh point, it makes no sense that UCT should have participated in this very expensive litigation.
But on the point of policy,
Yes.
one has to go back to what council does. That's what they do. They're not implementers. Same like in the case of the executive, national executive. They make policy, president or cabinet, but they're not the implementers thereof. They don't finalize and say this is how it's going to be implemented and these steps have to be taken. Broadly, you make policy. That's a function of council. So the argument then of when we say, look, this is policy and I think there was a reference made that Senate or somebody, the executive or somebody, management of council, of the university will have to implement, because it would be difficult for council then to sit and really flesh out in all facets of policy they implement what is right and what is wrong and how it's going to implement, and they won't be able to do that to function properly.
The second resolution, for example, what more needs to be done? It's unclear, but no further step needs to be taken. You want to know, you've got to be careful of any activities that involve author affiliations with people affiliated to the IDF or the broader military establishment in Israel. As I said, the term policy, it doesn't have magic to it, because if one looks at Gelyke Kanse in paragraph 18, we did hand that up. This is about language policy at the University of Stellenbosch. And it says the Laker Council sought to introduce evidence showing that the 2016 language policy is currently being implemented in a way that gives warrant to its fears about sidelining Afrikaans. But the High Court rightly rejected this evidence, as must we, says the Constitutional Court. 2016 language policy was implemented with effect from 1 January 2017. The Laker Council challenge was brought before that on 30 September 2016. That makes these proceedings a facial challenge to the policy itself. They're not an as-applied challenge. In other words, you can facially challenge in court a policy, and that's what's being done here. Whether you call it a policy, whatever you call it, this thing it's real, and it's being challenged. And the Laker Council says you can do that. The seventh reason is the IRA definition. And this addresses the point I think was raised by Lord Justice Scher about what the first resolution does as far as rejecting the IRA definition is concerned. And we make the point firstly that UCT has never advanced the interpretation that it's only a limited rejection. It understands the first resolution to reject the IRA definition, repeatedly says that it has done so, and we have given a long list of references in footnote 45 making that point. So on the pleadings, this issue has been taken out of dispute. And hence also the then Vice-Chancellor's admission that the first resolution breached the agreement with the Donald Gordon Foundation. Secondly, Council's reasons for the first resolution reveal that it considers IRA to rest on a conflation of Zionism and Judaism. So, as far as Council was concerned, this is fundamental to the IRA definition as a whole. So to reject the conflation, as far as Council was concerned, was to reject the definition, and that's consistent with the case in the answering papers. Thirdly, at the same time as it rejected the IRA definition, Council adopted what's called the Jerusalem Declaration's dynamic understanding of what constitutes anti-Semitism, and perhaps also that's an answer to his Lordship Justice Scher's point. Council doesn't just reject something and adopt something else, simply saying we reject IRA and adopt Jerusalem Declaration. They adopt the Jerusalem Declaration's dynamic understanding of what constitutes anti-Semitism, so everything gets circumscribed. Although so describes, also not in dispute that Council adopted the Jerusalem Declaration and that it did so instead of the IRA definition, because although Professor Mendelsohn says that the two can live together, that's not UCT's stance. So on Council's own version, it rejected the alternative. So this just brings us back to the point that Council had no evidence before it regarding the weaponization of the IRA definition. And again, I must stress, we're not saying that this court must find that there is no weaponization. The court doesn't have to make a finding. It's just that there was nothing before Council. As also Mr. Justice Scher said earlier, they only had these two resolutions of the Senate before them. It also had no evidence before it regarding the non-weaponization of the Jerusalem Declaration. It is relevant that Mr. Perumal Sami, who is by no means an ignorant person, as this court well knows, he had not heard of the IRA definition of the Jerusalem Declaration. One must always be wary of benefit of hindsight. One's here and that's all one's been talking about, and one thinks, oh, I must have always known about these things. But why? These are not things that are common knowledge or known to everybody. And he said he didn't know, and he would be by no means the only Council member who wouldn't have known these things. So Council here again, they ignored relevant considerations, the first question. That ignorance bears no link to passing an anti-Semitism resolution in the university's best interests, the second question. And given the centrality of weaponization to Council's reasoning, their complete absence of knowledge or information about this paints the entire process with irrationality, the third question. We must repeat again in this context the council was not informed by its chair that he had signed not once but twice an agreement committing UCT to the IRA definition, with UCT having drafted the final version of that clause. This is despite the fact that the various items of evidence that the chair invokes to malign the IRA definition predate his signing of the donor agreement. They existed, but he didn't know about them, or he doesn't say he knew about them. Our learned friend Mr. Budlander addressed the demerits of the IRA definition, but this with respect simply confuses appeal with review. The merits or otherwise of these definitions constitute no part of the review application, and validly they could not have. We can't come to this court and say to this court, it's for you to decide which is the better definition. So to invite this court to find that the IRA definition was correctly rejected by counsel is to ask this court to venture into areas which are wholly irrelevant and where divergent views are held by a range of people, both expert and non-expert. This court has been told that there are accusations of weaponization also against the Jerusalem Declaration by the Palestinian Solidarity Campaign and Middle East experts. So our learned friend Mr. Budlander was keen to show that the IRA definition does indeed conflate criticism of Israel with anti-Semitism, and we say with respect that is not relevant. It does overlook, one has to go there, the language of the definition itself, which is careful to use the subjunctive, and to say that it all depends on the overall context, and there was no answer to this in the answering papers.
Wasn't that considered with regards to the ultimate resolutions that was taken? In other words, one cannot consider it as irrelevant what it means, because it was one of the resolutions that lay. It is relevant, very relevant, in my view, because that's why the Donald Gordon Foundation ultimately, that was the main reason, I would imagine, as to why, because of the adoption of the other resolution, as to why they, and the rationality there one has to look at. So I with respect, disagree with you that it cannot be relevant, the two definitions, because it goes to the heart of, actually goes to the heart of this case.
I should make myself clear. The point is this: it's not for this court. The court is not called upon in this case, not by the case we've brought, to decide whether the IRA definition is a good definition or a bad definition, or whether the Jerusalem Declaration is a better definition or worse definition. This court, with great respect to it, is not in a position to do that. These are academic debates, and there are arguments on these papers going both ways.
As set out in the DA case, if one has to look at it, one doesn't, but it is a relevant issue as to, it became relevant as to why they took the resolution, and it became relevant as to why it was whether it's right or wrong, that was fast to decide. That's the point I'm trying to make.
It was quite correct. There was a consideration by certain members of council that the Jerusalem Declaration is a better instrument, and they didn't like the IRA definition. They talked about the conflation of it, and that informed the decision. But that's all.
And whether they were correct or not, this was decided. That's the point.
Yes. Yes. But my lord, just to stress this again, what this court does know is there was no evidence before it. And we come back to our original point. You can't, as an organ of state, jump to your conclusion. You've got to get there step by step. And you can't, as a council of a university, come to a decision on a definition. You don't even have the definitions in front of you. The court will have seen these are not short documents. They're long. We can all read them. We are lawyers. We may be more skilled at reading them than many other people because that's what we do for a living. But they complicated. They didn't even have those definitions in front of them. And they had no other material before them.
And they knew, some of the councils knew that funding in a fairly large amount was contingent on the one definition. And that definition, in fact, had been put forward by the university in the document of the donation agreement.
Yeah.
It put forward that. So if it was going to reverse that, it needed to be quite careful and sure about what it was doing.
Yes, my lord. So this court, having read expert evidence by Dr. Williams and Professor Hirsch, having heard from the amici curiae, it has far more information before it than council did on 22 June 2024. And yet I feel I can fairly make the submission to this court that this court will not feel confident to rule on the merits of the one or the other. But like with counsel, it's simply unnecessary for the court to do so. Ultimately, this is the reason why we say no weight needs to be attached, in this case, to the affidavits of the amici curiae. They take this matter no further. Then very quickly to wrap up the eighth reason, reasonableness. The previous 7 reasons concern rationality and lawfulness and suffice for the relief that is sought. But counsel's duties do not end there. Counsel's policies must justifiably limit constitutional rights. So even if it acted rationally in its process of reaching the decision it did, which we strongly submit it didn't, counsel must also have acted reasonably because both the first and second resolutions limit constitutional rights. We must stress the fact that counsel did not consider this question before passing the resolutions. We have the very, very limited input from Dr. Manjra as to a conclusion that he says was reached by the Academic Freedom Committee. But what Mr. Perumal Sami says, and this is, if I might ask the court to go there, in volume 4D at page 1902, and with respect, it matters that Mr. Perumal Sami is a lawyer when he says this. In paragraph 98.5, he says, council members were effectively told by Dr. Manjra to accept that the limitation on academic freedom was reasonable and justifiable without knowing what the nature and extent of the limitation is. 98.5, my lord, on 1902. And then paragraph 99, the interim vice-chancellor indicated there had been no discussion on the nature and extent of the limitation at all. So this was not properly considered. Your lordship and ladyship, when assessing that limitation, must ask if the limitation is reasonable and justifiable. That's a standard more exacting than mere rationality review. It must consider the availability of less restrictive means to achieve the purpose behind the resolutions, including the factors in section 36 of the Constitution. That's common cause on the pleadings. It's not disputed. And I can just give the court, maybe the references are here, in fact. answering affidavit. Yes, footnote 55 has the references. Mr. Ahrens, as we also say in that footnote, accepts that the justification of the limitation of academic freedom is primarily a matter for legal argument. And also addresses our learned friend Mr. Budlender's submission. The court cannot ask whether the first resolution was necessary. Our heads of argument explain why both resolutions are substantively irrational given their open under-inclusiveness and vagueness. I'm going to come back to that in a moment because there's a concession on that, certainly in regard to the second resolution. But even if rational, the resolutions are unreasonable for those reasons, and we set that out in paragraphs 113 to 139 of the heads. Less restrictive means were readily available, and again, we refer to the statement of December 2023. That's a less restrictive means of indicating the university's position in regard to Gaza. UCT could have done what other universities, both in South Africa and around the world, did by adopting resolutions that did not infringe on the rights of individual academics. It's a very unusual position, as the papers show. Unique, as far as anyone could discover in these proceedings. And that goes directly to constitutional rights. As we understood the argument of our learned friend, the main thrust of UCT's defense to this ground of review is ripeness. It says the resolution's details and the extent to which they limit academics' rights will be determined by the executive, and we've already made our submissions regarding the weakness of the ripeness argument. These are not small irregularities with respect. What counsel did here constituted wholesale, serious, and flagrant infringement of constitutional rights which warrant this court's intervention. We do not say, it's not our case, that counsel cannot under any circumstances adopt resolutions against Israel or any other country. We've not suggested that there was anything amiss, for instance, with the resolution adopted in December 2023. But counsel must get there through a proper process. And this brings us to this point. I started my argument last week by referring to all pay, where the court referred to optimality of outcome being achieved through following a proper process. If a proper process had been followed here, optimality of outcome may have been achieved by conceding, as our learned friend did, that the second resolution was flawed as to over-inclusivity, under-inclusivity, and vagueness. Our learned friend was also conceding that the process that resulted in its adoption was a flawed one. In effect, if you'd done better in your process, you would have had a better product at the end. Setting aside the resolutions does not stop UCT from starting afresh. It's not an interdict application. But if it were to do so, counsel would this time have to weigh the benefit against the harm you submit. If it does that, it may be able at the end of the day to adopt a resolution that does not compound the harm already done to others, in particular UCT students. Finally, my lady, my lords, bias and costs. Deliberate non-disclosure in our submissions suffices for a finding of bias, or at least a reasonable apprehension of bias. That non-disclosure not... Yeah.
On papers as considered by the Constitutional Court in Canada. You're still persisting with that?
Reasonable apprehension of bias. Having heard the argument of counsel on behalf of UCT, we stand by our criticisms of the conduct of the chair. The court has also asked me about that this afternoon. If our case is upheld on deliberate non-disclosure and breach of fiduciary duty, then a punitive and personal costs order is warranted. We submit. We have in volume 3 of our heads of argument dealt with the issue of costs, and we would ask the court to have regard to that. Those heads primarily invoke the contents of the explanatory affidavits of Mr. Perumal Sami and Ms. Phelps, and the contents of those have not been seriously gainsaid. This litigation is both a result of and a perpetuation of a governance crisis at UCT. The university itself should not bear all the costs of the litigation, but those responsible for governance at UCT, and we've identified the chair and certain members of EXCO, should shoulder the costs to the extent determined by this court. They bear considerable responsibility for the harm. As the court pleases.
Bear with us, Mr. Yes. Judge Chair would like to just ask one more question.
So if I can sum up, your case really is that there was non-disclosure, whether it was deliberate or not, of a material factor that should have been put into the scope, financial implications. It was mentioned by certain members, but it was never explored, it was never debated. The chair had information, the vice-chancellor had information, and the other 3 members of EXCO that were there also had the necessary information. None of them put that information before council. You say on that basis the decision was irrational. You say it doesn't really matter whether we go paja or legality, rationality. And then if I properly understand, you say that the duty to consult, whilst it's quite clearly stipulated under paja review, here it comes in because of the fiduciary duty, which you have as a council member. I think that's what you say. You have a fiduciary duty as a council member to make sure that when you take decisions, they're properly informed decisions. If you're sitting with information that's important, you must put it to council in the discharge of your fiduciary duty so that it can go into the pot. If they then still decide to do what was done here, well, good and well. But if you don't do that, then on the process, you say this is a process review. The process that was adopted was not one that is acceptable in accordance with the requirements for this kind of body.
All that is best interests of the university, the statutory.
Primary consideration. And does it make any difference at all that these were donations? They don't go to the operating budget and anything like that. They don't.
It's just donations.
Students lose funding, so that makes no difference. But in any event, donations are only one part of it. We say that's a non-disclosure, but we also do say there should have been an investigation on impact. That also wasn't done. So your lordship is quite correct. We've made a big case out of what was actually known and not disclosed, whether deliberately or not is not salient for the outcome, but also more generally we say certain, and consultation your lordship mentioned, and that's part of the case, but also we say an impact assessment of some kind should have been done as in 2019, because, for instance, I took the court to the fact that in 2019 it found that the risk of loss of funding from the United States alone was 660 million at the upper end and 330 million they thought was best case. That's of course tremendous amount of money as 2019 money. So we say something more should have been done. So there was further information also should come into it. We refer also to the bishop opinions, which are very salient. The bishop opinion said the court council can't do this. That's his conclusion. Again, whether that's right or wrong, Why is this or a similar opinion not sought by counsel? So all those questions, but your lordship is correct. The focus has been on these known facts that were not disclosed, but there are also unknown facts that should have been investigated.
One final point I need to make, Chair. Sorry. Mr. Secretary. The ramification implications of this decision are of great concern, because at the heart of it, all in all, it's about academic freedom. I think in respect of both resolutions, and also how it interplays with how funding and outside funders and donors may have an impact on the policy and decisions of the university. And I must say that weighs heavily, and I'm very concerned about that, speaking for myself. And for instance, follow the line or toe the line, do that decision. Let's say it was something else. This is what we are, the funders. Follow the line, do what we say, because ultimately it boils down to that, although the process had to be followed. And that is something which bothers me ultimately, as to how do we, some of the ramifications of it. And how it might be perceived by some persons, rightly or wrongly.
So this is partly about donor funding and partly about all the other issues that His Lordship Justice Sher asked me about and which I sought to address. But even on donor funding, the University of Cape Town was not obliged to enter into a contract that referenced the IRA definition. That's entirely its election. It doesn't have to take money from any donor. The point is, though, once you have entered into such a contract, if you breach its terms, there are financial consequences. And all we say is that should have been known by council members. That's the important point. So there's nobody who said to the University of Cape Town, nobody held a gun to the head of Mr. Arends and said, you must sign this. They said, if you sign this, you get 200 million rand. It's a negotiated contract. Here are the terms. They sign it.
But that's the effect ultimately, if one should have regard. I agree with the point.
Yeah. Yes.
That's the effect of it. And
the point about the contracts of donation.
The donors play, in this particular case, the role of the donors, it weighed heavily in this case. It plays a big part in this case. Look, we're not, and I'm in agreement with you and everybody. We're talking about a lot of money here for university, and especially for the Dell Foundation, we talked about. But anyway, that's something I have to work out for myself.
A donor contract is quite an unusual agreement because there's no damages claim if you breach a contract of donation. All you're doing is you're being given money. If you breach that, you don't get the money. So in fact, you're not even tied into a donations contract. And they did. Yeah, this one they breached and it ended. It was cancelled, and then they don't get the balance of the money, and the 20 million rand, whatever was paid, has to go back. But so you're back in a neutral position, as it were. You just never had a donation contract with the Donald Gordon Foundation. It's not a punitive contract. Again, no gun to anyone's head. You voluntarily enter into this contract. If you breach it, you're going to lose the money that you would otherwise have got. It's additional to the funding from the government and whatever, from parents of students. But you're going to lose that. And the only point here really is council should have known this and considered this. Nothing further. But it's a very overstated idea with respect in UCT's papers, this idea about don't strong arming the university. These are the weakest contracts imaginable because you can breach with impunity. There's no damages claims. You only have to, you don't get the rest of the money, or you have to give the money back, or the combination of those two. That's all. So no one's getting strong armed. You elect to enter into such a contract, twice in this case. If you're going to breach a term of it, tell the council. As the court pleases.
My lady, there were just two things. The court will be pleased, but I'm not going to try and
have a bite.
no doubt about that. One is just a schedule correcting some of the factual inaccuracies that were made on behalf of Ms. Phelps and Mr. Kessler by their respective counsel. So we've just done a table which will make it easy for everyone. We will send a copy to Ms. Kazi. The second is a more difficult request. There were a number, I counted 7 factual inaccuracies that were made by Mr. Fagan. And the problem is that he's now submitted fresh argument, which was not in his original argument, under the guise of a note. So I think the best thing to do, not to prejudice my client, is to actually submit a note to respond to the document he handed up today.
Because I'm not responding to your submission.
It purported to, but in reality, it introduced new argument, and it, in fact, mischaracterized the argument. And then it misinterpreted the facts. And I can do that now, but I think that's not prudent. It's what we must request is simply a chance to put up a very short note to deal with those.
This is a little bit of a tricky situation.
I know.
Mr. Fagan may well want to respond to what he would have written.
It doesn't matter to me, my lady, if he wants to respond, but I would not be doing justice to UCT if I allow some of the factual misstatements to remain unchallenged.
On this case, if there are any trees left in the national forest,
So one thing, Justice Henry, I will send it on email.
I've never ever seen a supplementary rejoinder affidavit. I didn't even know one could get that, but we are way past that.
One was Western, there was a supplement and a solid joint.
No, and it could have been avoided if there was not this attempt of introducing more paper to prejudice us. And so we have to respond to it, unfortunately.
Let's give Mr. Fagan a respond to what is being said.
I believe that we were strictly replying. I don't believe there was any new argument, save in response to issues that we hadn't previously dealt with, which was the mootness, the right. Well, I dealt with mootness because it was in their heads. Ripeness was not in their heads. I responded to that. The curing argument, I responded to that. It's not apparent to me that we went beyond what is entitled to a party replying.
We won't know exactly what Mr. Nugaitobe has in mind.
Decide whether I exceeded my brief and what I'm entitled to say in reply, because your ladyship did hear the arguments of our learned friend, and so the question is whether I actually ever went beyond what was said by him. Otherwise, we really are going on with this case. I'm tired of it.
The ideal situation would have been to hear Mr. Nugaitobe now, rather than wait for heads. We have very little control over what's going to be said in those supplementary. If you can hear now, we're able to say, no, that was not the. I don't know how.
I mean, you want to
Change something.
To be a second bite on the cherry. But I think, in all fairness, if you want to point out inaccuracy, then it would be hopeless to grant you the opportunity.
I promise you, it's simply to point factual inaccuracies. And your leadership can stop me and say that's not an inaccuracy. I can do that now, but I don't want to hold everyone simply because I want to talk. I understand. That's why my final request was simply give me 5 pages to simply point them out, and then I'll submit those next week. That was my original request.
Milady, may I intervene and just say we're agreeable to that? 5 pages. We hope not to have to respond. If there's something there that really reports for a response, we will put that in, but we hope we can enter it on that basis.
My juniors must indicate. The indication I'm getting, and my lord, my lady, if I see your change in your facial expression, it's not me, it's my juniors. It's Friday next week. Yes. Oh, it looks like there's general consensus. Yes, I think we can compress it into 5 pages. If we do 11 points.
5 pages on both sides.
No.
1-7.
So, as I say, I'm happy not to speak now and simply to put everything in the note. Thank you, Madam. Yes.
Thank you very much to the councils and their teams. And judgment is obviously going to be reserved. But it's going to be a very difficult one. But it will be reserved, and we thank you for your very helpful submissions. Have a great evening, Corrigence.